of Justice.
Let's call the matter.
Harrinauth Justice Appeal Number CB3 of 2006 between Harrinauth Ramdass and Salim Jairam, subject for Roki, Amina Mohammed, Asaf Ali Mohammed, the Registrar of the High Court.
May we have the appearances?
Oh, I'm so sorry. May it please your honors, I appear for the appellant and Mr. Adrian and Amaya is with me.
Yes, thank you, Mr. Nadlan.
May it please your honors, Mr. General tonight, appearing with my cousin, Mr. Tashir Khan on my left and Mr. Mohammed Khan on my right. With your permission, Your Honor, Mr. Tashir Khan will give the presentation on our behalf. We've all had an input and we decided that he will make a presentation at the time it comes.
Mr. Punai.
Yes, sir.
Yes, so thank you, Mr. Punai. May I say at the outset that we are grateful for the voluntary assumption by you and your colleagues of the role of amicus curiae to assist us in deciding the legal issues that arise in this case. Is there any appearance for Amina Mohammed? No? Well, I would ask the registrar to indicate what steps were taken to bring this date of hearing or this appeal to the attention of Amina Mohammed. We had ordered in a case management conference the last one held that the registrar adopt the most effective means available of informing her of the date of hearing. Madam Registrar.
Your Honors, first you want suggestions made then subsequently wrote to Mr. Asaf the attorney at law from San Fernando, had previously contacted to indicate that he was approached by the second respondent to act on his behalf. Mr. Hussein subsequently provided me with the telephone number for Mr. Hassan Hussein, the son of Amina Mohammed. I contacted Mr. Hassan Mohammed on the 2nd June 2008 by telephone and he confirmed that he was the son of Amina Mohammed, who was the second respondent in this appeal. And I informed him on the telephone that the hearing of the appeal was scheduled for the 9th of June. And I asked him for his address. He gave me his address in there. And I sent a sealed copy of the notice of hearing of today's appeal to Mr. Asaf Mohammed by Federal Express to him. According to the receipt from the website, the Federal Express website, the notice of hearing was delivered to Mr. Asaf Mohammed on the 4th day of June 2008 at 11:05 a.m. I also sent by Federal Express to Amina Mohammed at her address at number 19 Village Quarantine Lewis Guyana and to the address at Warren Quarantine Lewis Guyana. Copies of the notice of hearing for today's appeal by Federal Express. Both these packages were delivered on the 4th day of June 2008 to 1A Mohammed, who signed for them at 11:05 a.m.
The information which had previously been obtained was that Amina Mohammed had emigrated from Guyana and was living somewhere in North America. Is that right?
Yes, President.
Can the name called, let the name Amina Mohammed be called? Thank you. Salim Jairam has been substituted for the first respondent, low-key, for the purposes of this appeal. Is there anyone here on Salim Jairam here?
No, Your Honor.
He is your clerk, I think.
That's correct, Your Honor.
But he is aware of today's hearing, I take it.
Yes, Milad. In fact, Milad, he received a notification of the hearing sent to him by the registrar.
And he has not wished to participate.
No, Milad.
Yes, thank you. And finally, the registrar of the Deeds Registry, was that notification sent to the registrar and Madam Registrar?
Yes, Your Honor, on the 2nd of June 2008, notification was sent by fax, subsequently followed by hard copy.
I don't think that party, that the registrar has participated in this case. Has she?
Milad, based on the record, there has been no participation at any stage whatsoever from the registrar.
Yes. Right, well then I think we can proceed with the hearing now. I did say that one of the directions we gave was with regard to the time allocated for oral submissions today. I want to stress that counsel ought not to feel under any obligation to utilize the maximum time allotted to them. We are not wishing to rush anyone, but we have read the written submissions and have and will consider the authorities submitted, so that in no circumstances you should take that into account in tailoring your oral submissions for this occasion.
Milad, speaking for myself, I do not think that I will use up 90 minutes that
Yes, but
has been allocated to me.
I am grateful for that. Well, let us proceed. Mr. Nadlal, would you like to begin?
Right, I got it. May it please Your Honor, Your Honors, as was indicated earlier, submissions were made in writing twice for and on behalf of the appellant. Your Honors were kind enough by a letter sent to me by the Deputy Registrar and the Marshal of the Court dated 2nd of April 2008 to itemize certain issues that Your Honors prefer to hear me on, and with Your Honor's leave, I will try to treat with those issues. In that letter, Your Honor, it was indicated to me that rather the opportunity was offered to me to make any submissions by way of alterations or amendments to the issues particularized. And Your Honor, in pursuant of that opportunity, I injected into the set of issues itemized by Your Honor an additional one, which in my humble and most respectful view is central to the issues raised in this appeal. And Your Honors, I structured it this way. Whether a purchaser in an agreement of sale in respect of land who has paid a deposit or has paid off the purchase price and entered into possession thereof acquires an interest in land which the law recognizes and will protect. Your Honors, I humbly consider that to be a very important issue in the determination of the matters of controversy which are raised by this appeal. Your Honor, instrumental to the address of that question is the inevitable construction of the Civil Law of Guyana Act, and specifically Section 3 of that Act, because therein lies what I think, respectfully, a problem that has existed in Guyana since the enactment of this legislation. And I would invite Your Honor most humbly to perhaps express a view with respect to the construction of this section. And if I may read, the common law of the colony shall be the common law of England as at the date aforesaid, including therewith the doctrines of equity as then administered or at any time hereafter administered by the courts of justice in England, and the Supreme Court, meaning of course the Supreme Court of British Guyana, shall administer the doctrines of equity in the same manner, and I stress that, Your Honor, by the underlining, as the High Court of Justice in England administers them at the date aforesaid and at any time hereafter. Your Honor, I pause here to emphasize that in my humble submission, the doctrine of equity was introduced into Guyana with all its facets and with all its concepts and all its principles. Based on the express language of this section, I respectfully submit that there was no exclusion of any aspect of the doctrine of equity when the doctrines of equity were received in Guyana in 1917. And that is the first point that I wish to emphasize.
But Mr. Nanglao, what about the proviso to paragraph D?
I'm getting to that, please, Miller. I'm getting to that. The English common law of real property shall not apply to immovable property in the colony. So the English common law of real property shall not apply to immovable property in the colony. So that's a very clear statement that ought not to create any form of misconstruction. There shall be, as heretofore, one common law for both immovable and movable property, and all questions relating to immovable property within the colony and to movable property shall, subject to the law of the colony, and I pause here, Your Honors, to emphasize that again, subject to the law of the colony, shall be determined, construed, and enforced as far as possible according to the principles of the common law of England applicable to personal property. And then I come to Your Honors, your Millard query. Because I agree with Your Honor, that is where the problem comes in, the proviso. Provided that immovable property may be held as heretofore in full absolute ownership. That's the first line that has caused the controversy.
Full ownership. You have the word absolute.
Full ownership, I'm sorry. Which shall be the only ownership of immovable property recognized by the common law and shall not be subject to any rule of succession by primogeniture or preference of males to female or to any other incident attached to land tenure or to estate in land in England and not attached to personal property in England. So, Your Honor, I regard this as a two-pronged requirement. If it attaches to land,
May I ask you,
yes, please.
to pass something for me in this proviso, where it says or to any other incident attached to land tenure or to estates in lands in England. Do you say that the words to estates in lands in England is governed, they are governed by the words attached to? In other words, it reads like this, or to any other incident attached to estates in lands in England. The other, it is not that the words or to estates in lands in England is not governed by the words subject to. You follow?
You know, here is where it is in these two lines that the problem lies. These two very lines. I offered my own humble interpretation of it at paragraph 3, which appears on the following page 4.
Yeah, what is that?
Your Honor, it is whatever it is that attaches to land in England must attach to personal property. And only then that applies to Guyana. So that entailed interests, estates, which do not apply to personal property in England cannot apply to Guyana. That is the interpretation I humbly wish to place on that line.
Counsel, if I may ask, in construing this enactment, Chapter 601 has two titles, a short one and a long one. Couldn't you get some help from the long one, sir?
I thank Your Honor for your guidance. An act to codify certain portions of Roman Dutch law of the state and in other matters to substitute English common law and principles of equity along with certain statutory provisions for the Roman Dutch law. Your Honor, I humbly regard this act as a piece of legislation which was designed to introduce into Guyana English law and to abolish Roman Dutch law. And if I direct Your Honors respectfully to section 3, the marginal note is the abrogation of Roman Dutch law. And this is where the English common law and equity was introduced in a wholesale fashion into Guyana, and Roman Dutch law went out.
But
And
that is precisely what the long title says.
Precisely. I agree with Your Honor completely. And I thank Your Honor to have directed me to the long title.
Well, Mr. Nanlal,
Yes, please.
in relation to the proviso, if you read it disjunctively instead of continually, when it says, and shall not be subject to any other, let's forget the succession by primogeniture,
That's correct.
to any other incident attached to land tenure. That's separate. Then it goes on, or to estates and land in England. I see it as two separate things, not being connected. Wouldn't it read that way? Any other incident attached to land tenure?
But Your Honor, I humbly beg to disagree. Because the and there, and of course I go back to our interpretation of General Clauses Act, and is conjunctive. And unless the legislation expressly so informs, then to interpret and to be disjunctive, I think would not be keeping. But
I wasn't referring to the last and, which is and not attached to personal property. I
Or
was
to estate.
thinking to any other incident attached to land tenure, as and disjunctive jointly to or to estates in lands in England.
yeah, no, I agree with Your Honor. That is disjunctive. But in my humble view, Your Honor, that doesn't address the issue. The issue lies, I humbly feel, in the last line. And the and that introduces and not attached. And I think instead of and there, it should be which is not attached or which are not attached
Let
to
me,
personal
What does it
property.
mean to do?
let me try and focus, if I can, on the point which I think my sister is also raising, and which has to do with how you read these words. That is to say, is this section, the relevant part of it, to be read in this way? And shall not be subject to estates in lands in England? Or is it to be read as shall not be subject to any other incident attached to estates in lands in England? You follow?
It shall not be subject to estates in England. Any aspect of estate, land tenure in England. I think that is clear. What is not clear is the last line. What is it that is not attached to personal property in England? That is where the problem lies, in my humble view. And I am saying that it should read, instead of and, which are not attached to personal property in England. So that estate, land tenure, of course, cannot apply to personal property in England and therefore cannot apply to land law in Guyana. Everything else which attaches to personal property in England applies to Guyana. And there is where my argument comes in. Equitable interest, trust, etc. applies to personal property in Guyana and therefore by the express provision of this legislation applies to the law of Guyana. That is my respectful interpretation. And that's the interpretation I invite Your Honours to adopt.
Alternative, Mr. Nanlau, is it not more straightforward to accept that if land is held as heretofore in full ownership, which shall be the only ownership of immovable property to be recognised now by the common law, that you're referring to, as you suggested, absolute full ownership, not divided ownership between legal and equitable ownership, especially when, if you go on to Proviso 2, where there's a further reference to Guyanese immovables, we are concerned with existing Guyanese practice. So the right of opposition in the case of both transports and mortgages is going to continue to be the law.
Your Honour, that is a vital issue that Your Honour has raised. And I will treat it this way, Your Honour, if with your kind permission. That is why in my submission, I attempted to outline and analyze what was the law in the colony at the time, and that's why I emphasized when I was reading earlier, where the section speaks to subject to the law of the colony. 3D speaks to subject to the law of the colony, shall be construed, enforced, etc., as far as possible to the principles of the common law applicable to personal property in England. But there is the caveat there is subject to the law of the colony. And when you look at what the law of the colony was prior to 1916, you have a long line of cases in an unqualified way recognizing equitable interest. And that is why, Your Honour, I cited and I laid over to the court the article by Mr. David de Caries where he has enumerated those cases where equitable interest has applied. And I will read, Your Honour, from a passage from Duke, immovable property, which unfortunately I did not get an opportunity to append to my submission. And if Your Honours will permit me, I would like to read a passage from that book.
On which page?
At page 20, Millard. Page 20 at the bottom. In Dal Singh against Umrao Singh, LJ 12-1203, the plaintiff together with S and the defendant purchased a piece of land, each contributing his share of the purchase money. Transport of the whole piece was passed to the defendant on the understanding that he would transport to the others when called upon. In breach of that trust, he failed to do so. He sold 2/3 of the land to S, whereas in equity, he was only entitled to 1/3, and he was now seeking to carry out that contract by transporting that interest to S. The plaintiff opposed, and it was held that he had a right to oppose since he was equitably entitled to 1/3 of the land. The court will protect any equitable interest of the opposer in the res opposed. Your Honour, I respectfully commend this passage to this honourable court as the epitome of what existed in Guyana prior to 1917. Of course, time is not available to me to go through all the cases listed by Mr. de Caries in a very, very academic analysis, where he went through the law and he demonstrated by case law authorities what the position was in Guyana in 1917. There was a clear, unqualified, unreserved recognition of equitable interest in a series of cases.
But in that case, the question arose in the course of the opposition to the transport, did it?
That's correct, Your Honor. But I don't see that. I do not see, Your Honor, that makes a difference. The principle is there was a very clear, unequivocal recognition that equitable interest exists and the court will protect equitable interest. And that is the principle that I wish to extract and extrapolate from what I have recited with respect to
Mr.
that.
Daniel, how do you reconcile that with the Deeds Registry Act, which I agree came subsequent to the Civil Law Act,
Well,
and which recognizes full and absolute ownership?
Your Honor, I don't see a conflict. I don't see a conflict because when a person has I begin with the position that estate and entailed interest does not apply to Guyana. That is what the proviso excludes. Now, when transport is issued under the Deeds Registry Act, the holder of that transport holds absolute title. That is a position that I agree with. Subject only to the items enumerated in that section. I agree with that, and I do not see how that conflicts with a position that advocates that equitable interest applies to Guyana.
But equitable interests are not among those things subject to which the registered owner holds.
No, I agree completely, Your Honor. But if I have an equitable interest in a land, and by some artifice or some mechanism, another person, without regard, or rather with notice of my equitable interest, vests transport in his name, clearly that is not a transport that can be regarded as a full and absolute, or that confers full and absolute ownership, because that is a transport that is liable to be set aside. It is simply a document that cannot withstand the scrutiny of any type of analysis.
Is it not only according to the language of the statute? Is it not only in a case where the transport has been obtained fraudulently that it can be set aside?
Look, Your Honor, that is another misconception which appears in the judgment of the Court of Appeal. In fact,
I don't know about the Court of Appeal and misconception. What I would like you to show me is why that is not what the Act says.
look, Your Honor, bear with me one moment. Let me. Where is it? Where is it? The white. Submission. Oh. One moment, please, Your Honor. Section 22(1). From and after the 1st of January 1920, every transport of immovable property other than a judicial, etc., etc., etc. And then it lists the interest that is subject to it. Provided that any transport, whether passed before or after the 1st of January 1920, obtained by fraud, shall be liable in the hands of the party or parties to be declared, etc. Your Honor, this is a position that applies to any title, any document, any part of the world. There is nothing unique to that section, that proviso there, with respect to Guyana.
Well, what is unique is that in a system where you have registration of title, and that registration is intended to be conclusive, the only way of challenging the registration of the person who is shown as owner on the register is by alleging and establishing fraud.
Your Honor, I respectfully wish to disagree with that proposition, Your Honor. There is nothing in this section that says that fraud is the only ground. All it says is that you can set aside it by fraud.
But if it
As it must be done within 1 year.
If it says that the holder of the transportee is the absolute donor, subject to A, B, C, D, their list of interests which are identified. And then you say, provided that, and you have also an exception in the case of fraud. Doesn't that have the ring of a comprehensive code dealing with the conclusiveness of registration?
Millard, let me answer it, Millard, this way. If, for example, as is required under this very legislation, the Registrar of Deeds passes a transport without advertising it in the official gazette and vests it into Mr. Anamaya's name, there is not necessarily fraud there as we understand it. But that transport cannot stand. It cannot stand. If, for example, transport is passed and there is some duress involved, it cannot stand. But that's completely outside of fraud. So that the point I am making is that fraud, of course, unravels everything, including transport. But I am saying that to confine fraud as the only ground, as the sole and solitary ground to disgorge a transport is not a proposition that I
take your point. But the problem is that what we are dealing with here is not something like duress or anything of that sort. What you are really relying on is the existence of a prior equitable estate or interest. And one would expect that if the Parliament intended that the registration should be subject, in addition to the other interests, to the equitable interest, it would have said so.
Your Honor, yes, and had it said so expressly, perhaps I would not have been here.
Well, I'm sure.
The reason why we are here, Your Honor, is because of the failure of Parliament to legislate very clearly. And I am saying that within the confines of Section 3, there are words and there is within the language, impliedly and by implication, the recognition of equitable interest. That's why I cited phrases like subject to the law of the colony. That's why we go back to look at what the law of the colony is.
Mr. Daniel, when
Yes,
you
Millard.
get back to the deeds registry,
Yes, Millard.
where is the equitable interest?
It's not mentioned, Your Honor.
Well, it says very clearly, shall vest in the transferee the full and absolute title to the immovable property. I just thought that is very clear as to what interest vest in the transferee. It doesn't say subject to any equitable interest. In fact, it does tell you what it's subject to. It's subject to statutory claims, registered encumbrances, registered interests before the date of the advertisement, and the registered leases before the date of the advertisement. Those are the only things to which is a subject. And then if you can show that there's some fraud in the transport, that is another ground. But it seems to me that when you say vesting full and absolute title, you're dealing fully with all the interests that are capable of being contained in the land.
Your Honor, let me say that it is not clear. It has not been clear to the Guyanese courts for nearly 50 years, and it is not clear now. That is why there has been an inconsistency in the decisions.
But would you say that when you got to the 90s, in cases like Fazal and Anumontodo, that there's any lack of clarity as to what the law is?
But those line of cases, Your Honor, what they rejected completely the concept that equitable interests exist in Guyana. They reject that.
And on several occasions.
On several occasions. And if, Your Honor, in particular, there was one judge who featured very prominent in all those cases, and it was former Chancellor George, who seem to have an exceptional understanding of this area of law. Because when you look at the research that went into his work and his judgment, quoting the books from South Africa, etc., it was clear that His Honor had a tremendous understanding of this area of law. But Your Honor, and that is where all the other judges and all the other courts followed judgments rendered by the Honorable Chancellor George. And I'm saying that it's quite possible that the Honorable Chancellor could have been wrong.
Well, I think that the first case that determined this issue was the Kitty and Alexander Village Council matter where Chancellor Lakou, Chief Justice Lakou, not Chancellor, way back in 1961.
But Your Honor, he was acting before that, in 1923.
But I think he definitively said that
Yes,
there were
I think that was a clear statement, and it started from then.
Yeah.
And all the cases recited that, and they went, but none of the cases, Your Honor, they did any analysis of the section. They just followed Lakou.
Well, I must confess indeed that Chief Justice Lakou didn't seem to analyze it.
No, there was no analysis, Your Honor.
I agree, but that seemed to have been the,
yes, and that is
the start
where
of it. But I just wanted to draw your attention away from that for a moment to the Deeds Registry Act. The same section you cited of 22(1).
Yes, please.
Where registered interests are ones which are, their subject transport is subject to registered interest. And in section 2, the interpretation section, it defines what a registered interest could include. And it includes liabilities, rights, interests attached to immovable property by agreement, which means that perhaps, although it isn't generally done, but an agreement of sale could be registered and be regarded as a registered interest.
I am so happy that Your Honor pointed that out. Now let us analyze that. If I am to register an agreement, an interest acquired under that agreement, what interest am I registering? If it is not an equitable interest.
Well, I think you're registering, if you're put into possession, as happened in this case, you're registering your right to possession against the vendor or against any other person, and which would be subject to the transport. At least it will give the person who subsequently buys knowledge and notice.
Can I ask this question then, please, Your Honor? What in the law says that I cannot register my agreement as conferring upon me an equitable interest? That is the question I want to ask. And that's the question that I think is central. What is there in this Deeds Registry Act, in the Civil Law Act, which disallows me from registering that?
We don't have to answer that question, Mr. Natla, for the simple reason that you didn't register them. But you see, Mr. Natla, I mean, I am very conscious of the need to tread warily in an area which has been traversed by people who are much more familiar with the subject than I am. But it does seem to me that you have two hurdles to cross. And one is to establish that you have an equitable interest and that it is possible to have an equitable interest in land in Guyana. The second hurdle, however, which, as I see things at present, appears to be a more formidable one, but I'm not saying it can't be crossed, is the Registry of Deeds Act, the Deeds Registry Act, and that section to which we've been referring, which gives that absolute protection to the registered holder of the legal title, registered holder. And that is whether or not an equitable interest can prevail in the face of that provision. is a totally different and separate issue, appears to be, from the question whether there can be an equitable interest.
Your Honor's analysis is excellent. That is exactly
The first
the
issue,
two hurdles.
I'm only throwing out stray thoughts. But on the first issue about the restriction in the proviso to the Civil Law Act, it does seem to me that they could be argued that the references to primogeniture and, male tail and that type of thing establish a genus of incident of tenure, and that when the section goes on to talk about other incidents of tenure in estates, these are, it may be argued, are things which are just and generous and really are not apt to prohibit the existence of an equitable interest. But I am afraid of being blasphemy in the face of
Authorities.
Maybe go back to before I was born.
Mr. Nanwell, perhaps the real approach is if you're dealing with a registration system where the register is everything. And it doesn't matter what sort of interest you've got, whether I call them legal interests or equitable interests, they've got to be registered. And if they're not registered, then they are ineffective against someone who takes a transportable property. And it's noticeable that even in England, the home of equity and equitable interests and notice, the doctrine of constructive notice is regarded as too uncertain and grey and blurred round the edges. So the 1925 legislation tried to get more interest registrable, and in particular, of course, estate contracts became registrable. If they were registered, then they bound a successor in title. If they weren't, they didn't. And it seems to me you can say that the system of registration in Guyana, like in other countries, is designed to produce clarity, certainty, reliability, even at the expense of the hardship occasionally. But normally there is some way out, but only a very narrow way out. And here, of course, as the President suggested, Section 22 provides a code so that once you've discovered some fraud, then you've got 1 year in which to take action and you'll be fine. But if you don't take action, then you've had it, because the register is everything. And we don't care whether things are equitable or legal or whatever. They're either registered on the register or they're not.
Your Honor, well, that can be one way of Her Honor, Madame Bernard, can vouch for me when I say that agreements of sale are not usually registered.
Yes,
it's not. So
but
even if this was the system,
there's provision for them to be.
Yes, clearly there is. Unfortunately, in practice, that doesn't translate into practice. So, and we have, and these cases of this type come up regularly in Guyana, and the courts have taken the position that they have taken in this case.
But Mr. Snana,
Yes, brother.
couldn't your client have filed an opposition at the time when he became aware that Ali Mohammed had entered into some agreement with Loki, with his sister? Couldn't he have filed an opposition? Couldn't he have done something to preserve his interest?
Yes, he could have filed the opposition, but, Your Honor, he didn't. And that's the fact. He didn't. Of course, he was in possession, and the present position in Guyana is that the notice in the official gazette, which is published at the time when the conveyance is to be passed, does not bind a person who is in possession. It binds all the world except he who is in possession. And of course, I submit to the authorities. But to answer Your Honor's question, yes, he could have done that, and he did not.
You see, the Civil Law Act that speaks about immovable property being held in full ownership, and full ownership being regarded as the only ownership of immovable property being recognized. If equitable estates in land are permitted, wouldn't that contradict that section, that aspect of it?
Well, Your Honor, that very section tells us that the English common law of real property shall not apply, and what shall apply is the law of realty, of personality in England. And I have demonstrated with authorities that equitable interest exists in movable property in England. So that there is a conflict there as well. So one part of the section speaks to absolute ownership. Another part tells you that the law as to land law in Guyana is going to, it shall be the law of personality in England, and then personality has with it equitable interest.
But doesn't that take you back to 3D, which says as far as possible? It says a judge determined to construe this as far as possible. I mean, it must mean something.
If I may come to your aid, Mr. Vandal, or try to full ownership is not necessarily inconsistent with the existence of an equitable interest. The interest of the equitable owner, the rights of the equitable owner is to full ownership, as is the rights of the legal owner.
That's correct.
It's not like you have a knife tenant and a remainder man, or you have an ownership which is subject to some sort of fetter, like you can't transmit it to anyone but the son. So, it may be that too much ought not to be read into full ownership when you are considering the possibility of an equitable interest, particularly when the section goes on to illustrate what are the sort of things that detract from full ownership. And that is a right of primogeniture and all of that. And the references to, when you get to other estates, is to other incidents of the same kind of estates.
Millard, I could not have done a better job. Your Honor has captured everything that I wanted to say in relation to His Honor's query. And I wish to add that we must not discount the phrase before that, which says, subject to the law of the colony. Everything in that follows that is subject to the law of the colony. And what I'm saying, at that point in time, in the law of the colony recognized equitable interest. Just long before it is Registry Act.
It's subject to the law of Guyana at that time. It means that the law of Guyana in 1917 and at no other time, is that what it means?
No,
I mean,
it has to be.
Where does it say that?
Look, it has to be subject to the law of the colony, yes, at the time, prior to 1970.
But it didn't say colony, it says it's subject to the law of Guyana.
No,
So couldn't it be the law of Guyana?
of Guyana, yes. It says colony because at that time you were a colony.
Yes,
But now, if it says subject to the law of Guyana, shouldn't that be read in relation to what the law of Guyana is at the moment?
Certainly. I have no difficulty with that. Of course, that is how it has
If I
to be.
may, I'm inclined to be sympathetic with a lot of your submissions. But if you look at certain principles of construction and the principle of implied repeal, to the extent that these Registry Act was subsequent to the Civil Law Act, and if you look at the section 2 which talks of registered interest, you have a problem there. Because it says registered interest means and includes. And as a drafter myself, whenever you employ the term means, it means you are exhaustive in the definition. If you had said includes only, then I think your argument would have had greater strength. But the term is registered interest means and includes, which means that the particular definition is exhaustive. There is no more room for any other thing than what is settled there, and you have a problem. You know, so you have to cross the hurdle of the Deeds Registry Act
I'm aware
and
of
the
that.
doctrine of implied repeal,
I am aware of that.
which
And
you must consider.
I wish to humbly say that it's commendable that Your Honor is taking that approach, because at least there should be a pronouncement somewhere along the line so that there can be some, at least more certainty on this question. Because as a practitioner, you have sometimes difficulty in advising, as I'm having here now.
As I think, Mr. Nanlal, that Section 2 having been pointed out, I know I agree with you that it is not the practice in Ghana, hasn't been for a long time. But it seems in relation to the registered interests, maybe indeed, when you have agreements affecting land, they ought to be registered.
Well, Mr. Punai is here and we're all here. We'll go back and register them.
Yes, that position is reflected in many jurisdictions, but normally you don't protect the contract because you expect to complete the contract within 1 week or 2 weeks. There's no point in doing it. It's only when the contract is not to be completed for a significant period that you really need to protect yourself.
Indeed, in Guyana, sir, it's 3 months that the contract is taken. The conveyance is normally takes to pass title to the other side.
Very unrealistic time frame, which is never honored.
Which is honored in the breach, right?
2 years passed in this case and no action on the transport.
That's correct.
Not so?
That's correct.
I don't know. I mean, our lawyers I had not a little nervous between contract and completion.
You have, but Your Honor, this is a case in point where the title holder clearly, and that fact is not in dispute, sold it to another party, and the trial judge found.
I don't know. I mean, that far be it for me to criticize, but I would have thought that conveyancers in Guyana would have had about 2 or 3 clerks watching that consent like a hawk.
Perhaps, in fact, Your Honor, I don't know that there is a system in place for you to record the agreement of sale. If I hope respectfully that Your Honors, in your judgment, will make that clear that should be implemented, because I don't think that there is my friend Mr. Adamai is saying that they registered and perhaps that's done in Berbice, but it's...
No, you could if you go to the deeds registry and you ask that it be registered as the agreement registered as a deed. I don't see that they should.
Once it is registrable, it can be registered.
Similarly, so-called equitable restrictive covenants are registered in Guyana as servitudes.
Yes. Yes. But that is normally recorded on the document of title itself. It's recorded on the document.
The protection which the law intends to give to the person who buys land first from someone who sells it a second time is the ability to spot the attempt to take a transport of the land and the ability to prevent it. And that's, the responsibility of the party and the party's attorney.
Well, the only opportunity really that is available to the first purchaser is to peruse the official gazette,
Yes.
which ought to contain the advertisement.
Yes.
So there is an opportunity there available, except that, unfortunately, in this case, Mr. Ramdass, for whatever reason, did not know that it was being passed, so he was not as vigilant. And
Mr. Nandlal, I think that situation which has arisen here and will pertain only to the transport system. Now you'll have a land registry system, which I'm sure will take care of most of the problems you're talking about. There you have to register
yes,
your land title. So it's only under these old systems.
yes, with respect to transport, but as your honors know, most of Georgetown, in fact the whole of Georgetown, where the commercial property, the valuable properties are, the transport system applies. I don't know when it will change to registration of title.
Council, could you enter caveats in situations such as this?
I am not aware, Your Honor, that you can enter caveat to the transport. You can enter caveat with respect to registration of title areas. If you have a certificate of title, then you enter a caveat which is recorded on the register, and that ought to be put a stop on whatever is a caveat, and of course the caveat will explain ex facie what it is designed to preclude, and it ought to be honored by the registrar.
But in the system in Jamaica, if you have a contract of sale in respect of land and the transaction is not completed, to protect your interests, you may enter a caveat in the registry indicating that a contract of sale has been signed and so on and so on. And anyone who goes to purchase that land is affected with notice of the contract.
That may obtain in Jamaica, Your Honor, but the reason, the facility that is there available is because they have the registration system.
Let me ask you in this case, when in 1986, Mr. Ramdass brought the action for an injunction against Ali Mohammed, was there anything that he could have done in order to ensure that a transport was not obtained by Mr. Ali Mohammed?
He could have done two things. One, as Her Honor Madam Bernard is suggesting, he could have recorded his agreement there. But as I said, that's not.
And had he done that?
Well, it ought to be regarded as a registered interest. And secondly, of course, he could have opposed the transport at the time when it was advertised.
Yeah, but he couldn't do that until a move was made to obtain transport.
That's correct. So the only
there is no provision for registration of listings.
No, Your Honor, no. No, and I'm not aware of any. I don't think that there's any.
But our agreements for sale, I thought that they had not been accepted as registrable interest.
I didn't get that, please, Your Honor.
I thought that it had been said earlier that agreements for sale were not accepted as registrable interest. And you were urging us to extend the net of registrable interest to include them.
Well, I think that it hasn't been the practice. It's not that it has not been registrable, but the practice is not developed, and I think it is registrable under the Deed Registry Act, and I think that perhaps from now on some guidance will be given in that regard.
I hope so.
But I think if you go to the Deeds Registry to your agreement and say you want to register it, they are in duty bound to accept it under the Deeds Registry Act.
But jurisprudentially, the question still remains. The philosophical question is, what are you registering? Other than an ordinary agreement, what interest are you registering? If Your Honor, Madam Bernard answered the question by saying, well, you are in possession. Well, there are many, many occasions that will present itself when you are not in possession. So what are you registering? What interest?
The fact that you have an agreement under which you ultimately purchase the property that is there, it will be a form of notice, really. to avoid a situation is what happened here, selling it twice.
Under Section 22, it would be a registered interest.
Interest, that's the
subject to
point.
which-
That is precisely my point. So I am asking, I go to the registry and I said, I want to, pursuant to 22C, I want to register this agreement. The person who is there to administer the registration can very well ask me, well, what interest are you registering?
Oh, no, they can't. Because if you look at Section 7F, the Registrar of Deeds is in duty bound to register or record contracts, which would be an agreement, notarial bonds, etc. So you are registering a document in the same way as you're registering any bond or other deed.
So then, Your Honor, I am not being caught by 22C, because I'm not registering an interest, I'm registering an agreement.
Which is a contract.
Yeah, but Your Honor, that will not necessarily protect me, because the thing speaks of registering of an interest.
Once you're registered, it automatically becomes a registered interest.
What is the interest? As I'm asking. And therein lies the problem.
Yeah, but interest is defined as an agreement.
But the agreement confers upon me no interest in law.
In section,
Which section? Which section is that?
Where interest defined in agreement.
section 2.
Liabilities, rights, interests, special conditions.
I suppose it's whether this personal right to sue someone to obtain the land, technically an in personam ad rem right, is one that's attached to immovable property.
We will have to bend and twist and turn. But that is the problem. And that is the problem in this appeal. That is the problem with the law on this issue in Guyana.
Well, I think it's because the practice has grown up, not to register them. Perhaps if you had a system whereby all agreements were registered, this may not have.
But Your Honor, I still am not, and I say this with the greatest of respect, I still am not convinced that an agreement of sale qualifies. If we are accepting the position that equitable interest does not exist in Guyana, then the agreement does not qualify as a registered interest.
Well, it says in the registered interest, any interest attached to immovable property by agreement.
But I don't have possession. I pay my deposit. I have no interest, which attaches to the property.
But prior to the passing of the transport by the vendor, would the agreement give the purchaser an interest which he can enforce against the vendor prior to the vendor passing the transport?
He doesn't have an interest. I'm trying to persuade the court that he has. And if the court accepts that, I'm very happy. But what he has presently is merely a right, a statutory right, under the Civil Law Act, the very section 3 when you go later, to compel specific performance. That's all that he has, presently. And I am saying...
Which he would register.
Why can't you
That is not an interest.
The right is not an interest.
And if it's a personal right,
He can't mortgage that right, the specific performance.
No, because
He can't assign it.
No, because he has only an agreement for the sale of the property, but it's a right to sue the vendor for
It's a cause, it's a chosen action, I suppose. But I don't think that it qualifies as an interest. An interest in land.
But the only point of registering an interest is if it is effective against third parties.
Precisely. So if my
No
agreement...
point in registering an agreement for sale if it's only enforceable against the vendor or the other party. It's meaningless.
But Your Honor, these are issues, that is why I included this issue on the list of issues which Your Honor identified. Because this is where the appeal lies. This is a central philosophical jurisprudential question that we have to resolve.
Two separate questions, Mr.
But this one is certainly, the fact that it has taken so much time, my 90 minutes is going down quickly.
Yes, you're almost there.
I don't travel.
You are making a liar of yourself.
But I enjoy this exchange tremendously, Your Honor. I don't get this regularly in
I
Guyana.
have no complaints.
Sorry, Your Honor.
I said we are not complaining yet.
So, Your Honor, that is what I would like to say on that issue. And if it is that there is anything else that I can...
Mr. Namba,
Yes, madam.
I got the impression that maybe in these rural areas where you have people who cannot write and read, maybe most of those people would think that a receipt, as they call it, would be sufficient. They are not aware of the fact that you transfer property. That's what we think. For us, that's logical.
Yes.
I remember in Sint Maarten, a Dutch territory, where in the old days people thought a receipt was sufficient, and of course, under the civil law, that is not so either. So I was wondering if that impression is correct, that in these rural areas...
That is correct. That is correct. People believe...
a lawyer, I suppose.
Precisely. The lawyers don't understand it. It's a position right now. But that's why they're in this problem.
So all our ingenious solutions would not help those simple people.
That's correct, Your Honor. That is how Ramdass ended up the way he did.
Yeah.
But on that
And that was his sister.
On that same point, Mr. Nanda, I agree the receipt may not always reflect it, but once it satisfies
Yes, and
the statute of frauds,
that's
it
correct.
defines the property, the
And
amount
it's-
to be party to be charged,
Yes.
the amount of it.
In fact, Your Honor gave an excellent judgment, Rambarichi Nandalal, and Your Honor gave a judgment on that.
I can't remember that. Anyway, once it satisfies that, I would say that it satisfies...
The notary memorandum in writing, yes. Your Honor, Her Honor Bernard is explaining that there is a provision in our law that allows you, the receipt can become an agreement in sale, agreement of sale, because the law prescribes that it must be in writing. And of course, once it contains the requisite fundamentals, it qualifies as an agreement of sale.
But it doesn't qualify as a transport.
Right, the lordship query was on the other side. What protects him? He has nothing else. Just that document.
Qualifies as evidence of an agreement of sale.
Evidence.
Right.
Evidence. But the other question is the agreement of sale gives him nothing. Your Honor, the first issue that the court particularized for me to address is in what circumstances, if any, can a person who has entered into a binding contract to purchase land specifically enforce that contract as against a subsequent purchaser to whom transport of the land has been passed by the vendor. And of course, Your Honor, I cited Section 3DC of the Civil Law Act that introduced into Guyana the concept of the remedy of specific performance as it exists in England, as it existed then and as it perhaps exists now with no statutory intervention. So that the doctrine of specific performance, the remedy, is in Guyana in all its facets.
But Mr. I don't think we want to go through your written submission
Very well, Your Honor.
line by line. I think the yes, you go ahead.
Yeah, well, Your Honor, so that question I answered.
The point is that in order to enforce, it seems to me, in order to enforce an agreement of sale against a not the person who was not a party to it. That is the person to whom the vendor has purported to sell the same property the second time. You have to establish an interest in the property. And that is where equity comes in.
That's absolutely correct.
And if you don't you can't rely on equity to create that interest. And then you have only your right of action against the vendor for damages, compensation.
Can I say, Your Honor, that commercially, if, for example, I have an agreement of sale, I have purchased it, I can go to the bank with that agreement and begin the process of applying for a loan to pay off the balance of the purchase price. And then the bank will, of course, secure that loan by way of a mortgage, which will be executed.
You won't get a penny until the conveyance has been executed.
That's correct. But the point I want to make is that the bank is recognizing my agreement. The bank must be seeing some interest. And that is why they are because they could have asked me, look, you have nothing. Come back and talk to me when you have transport in your area.
Why can't that interest be restricted to an interest against the vendor, as opposed to an interest which carries over to a situation where the vendor has already passed transport?
Sure, it can be.
Your Honor's question is why that interest cannot be restricted.
You seem to be hammering away at the point that the person must have some interest because even the bank is recognizing
That's correct.
And I'm asking you, why can't that interest be simply confined to the circumstance where the vendor has not yet passed transport to a third person?
Well, I have no difficulty if there is an interest which will accrue. Right? The present position is that I can pay 99% of the purchase price as a purchaser, and I have no interest. Not against the vendor, not against anyone.
But you would have an action against the vendor. I think
of course I will have an action.
All of these problems arise because the terms of the agreement are never followed. If it says that the transport to be passed within 4 months and the person is put in possession, sometimes people stay in possession there for years and they do not seek to enforce their rights.
That's correct.
On the question of going to the bank, I think that most of the banks start the process of granting you a mortgage once they see that you have entered into an agreement that somewhere along the line you will become the owner of the property. And that mortgage that you're seeking is never passed until the same day that you go.
In fact, it's done simultaneously.
Yes.
I think that the introduction of the bank with respect is a red herring. The only thing the agreement does for the bank is to make it worth their while to investigate your ability to repay and to make preliminary arrangements to lend you the money because they think it likely that you will be becoming owner of the property.
Yeah.
But it has nothing to do with any interest or whatever.
I say that only to, I know, I agree with Your Honor. I give that example only to show that in the commercial world, the bank is at least, the banks, the commercial banks, are at least dealing, really, strictly speaking, theoretically speaking, they are not supposed to entertain you until you have the title in your name.
No, but let's go on, Mr.
Yes, very well. So, and Your Honor, to answer your question, as to, and I'm still on question 1, as to how one can enforce a contract where the title has passed to a subsequent purchaser. I cited that authority, that book, Specific Performance, the relevant pages, which explains. And then I cited as well Snell on equity, and that gives the example actually and advises that it should be done. And those are the two authorities, Your Honor, that I'll rely on And of course, Mr. Anamaya's submission, and I identified the pages that deal specifically with that issue, page 11 and 13 of the record.
Yes, Mr. Nandlal, perhaps one key issue as to whether someone has a property interest or not is a position on insolvency. And I notice in one of the cases you cited to us, there's a reference to section 39, subsection 5 of the Insolvency Act, which states no contract for the sale of any interest in immovable property shall be of any force or give any right of preference which has not been completed by transport, duly passed before the court or a judge, except that the creditor may claim under his contract as a concurrent creditor against the debtor's estate. So that shows that the contract is not a property interest capable of binding a trustee in bankruptcy. The person with the benefit of the contract is just an ordinary general creditor.
That's correct.
So what significance does that have for your case, do you think?
Well, that really, that is only adding another dimension to the problem that I'm facing here. That is something, but that's another issue. That's why, Your Honor, 6 judges, I hope that 7 judges, I'm so sorry, will shed some light on it.
What act was it?
The Insolvency
The Insolvency Act.
Yeah, was it?
Chapter 12,
1202, I think.
1221.
12 to 1, yes.
Yes, 1221.
1221, section 39, subsection 5.
And then, Your Honor, I move to issue number 2. Thus, actual possession of land by the first purchaser prior to the second purchase, fix the second purchaser with constructive notice of the first purchaser's contractual rights. And of course, the answer is yes, and I cited the authorities that I hope will persuade Your Honors that the answer is yes, and that that is a position which should obtain. And of course, I outlined also the obligation that the law imposes on the purchaser vis-a-vis the land in terms of his duties, etc. And Your Honor, I laid over a copy of a book that I found extremely useful, Commonwealth Caribbean Law by Samson Owusu, and that issue is treated specifically at pages 227 to 221. 241, I'm so sorry. And then I used the case of Canon Maraj to illustrate the point that notice, the advertisement in the official gazette is not notice to the person who is in possession, because that was the principle that one can extract, or the ratio of the case. And then, of course, Elsie Prasad and Charles Ogle, I used that case to demonstrate that the Guyana Court of Appeal recognized the doctrine of notice, because I think it was argued somewhere on the record by the lawyer who appeared, Mr. Bacchus, in the Guyana Court of Appeal, that the bona fide purchase for value does not apply to Guyana.
Mr. Nandlal, the whole this discussion about notice and whether it's a bona fide purchase or without notice, that is only relevant if you establish that there is an equitable estate vested in the first purchaser. And therefore, the prima facie, the legal person with the legal title who has obtained it after the equitable interest was created would be forced to cede the property to the equitable owner. But it's only if you reach that stage that the question of whether he is equitable, whether he's a bona fide purchaser for value without notice arises.
In the court,
And in this case, I mean, it's fairly clear that the Ali Mohammed was not in that position. Because if he didn't have actual notice, he almost certainly had constructive notice. But that is not the real issue in the case. You know, the real issue is what we have been discussing.
That is why, Your Honor, that's why my submission is structured that way. I put that first question as the central question. Because I think
we only have about 5 minutes.
Close from that. I'm guided, Your Honor. Then, Your Honor, the more important, or rather one of the more important questions is question 5. And I cited there that question, if I may read it. Having regard to the withdrawal by the plaintiff's counsel at the trial of the allegation of fraud against the first defendant, is it open to the appellant now to claim the transporter's pass to the second respondent was obtained by fraud within the meaning of section 23, it should have read 22(1) of the Deeds Registry Act? If it does, does the evidence support the claim? Well, as Your Honor pointed out, there is clear evidence. The evidence does support the claim. And, Your Honor, I cited the highest.
That fraud?
Fraud?
I don't know that the taking of the obtaining of the transport with knowledge of the other's prior agreement. I don't know that is fraud.
Well, if the second purchaser is aware of the first purchaser's purchase, and he's aware that the man is in occupation, and then he goes and acquires title in his name, I think that is fraud, Your Honor.
Was he aware of the agreement?
Yes.
Or just his occupation? No, initially what happened is that he saw him on the land.
That's correct.
But his occupation could have been relative to...
That's correct as well. That's correct. Except that prior to him receiving transport in his name, he was actually handed a copy of the agreement. And that's the clear evidence at the police station.
And by then he had paid half of the purchase price, hadn't he?
Well, that's correct, but he did not receive title in his name. So he also is without interest at that stage. If we are going to accept that equitable interest doesn't exist, and that when you pay the purchase price, you don't acquire any interest, then it applies also to him. So at that time, he had no interest. He got the interest at the time when he had in his hand a copy of the agreement. And if that doesn't afflict him...
But Mr. Nanal, this issue of what he knew and when he knew it would be relevant to the question of whether he could rely on a plea of purchase of value without notice, assuming, as I say, that the equitable interest had been made out. But I think that if you are going to deal with something like that on the basis that it constituted fraud within the meaning of that provision, which provides for the vacating of a transport, then surely this is something that you should make quite explicit. And if you explicitly abandon it because you don't get an amendment, and you don't challenge the refusal of the amendment, how can you come later on in the Court of Appeal or in this court and say, well, never mind my withdrawal, I withdraw the withdrawal.
Your Honor, is it, can I ask whether Your Honor is of the view that the concept of bona fide purchase for value does not apply in Guyana? I'm not clear.
I am asking the question at this point.
No, very well. But Your Honor, I submit that first of all, the concept of bona fide purchase for value applies to Guyana since the doctrines of equity have been introduced by the Registry Act, by the Civil Law Act, and that doctrine exists in Guyana, and the courts in Guyana have recognized it over the years. And that is why I cited L.C. Prasad and Ogu.
Yes, Mr. Nandlal, you may have the equitable doctrine of notice generally applied, but it may be excluded in certain specific statutory areas. So, as I mentioned earlier, take England, for example. Obviously, the equitable doctrine of notice is a long-standing doctrine, but to a large extent it's been superseded in the case of conveyancing of land in the interest of certainty and clarity. And the most famous House of Lords case on that was one where a son didn't register his option against his father. The father fell out with the son, and the father and mother got together, saw a good lawyer who said the son has not registered his option, so if the father sells to the mother will take free of the son's option. So she bought the farm for a mere £400. As you might imagine, Lord Denning said that was fraudulent. But the House of Lords said no. Under this strict system of conveyancing, certainty, reliability is absolutely crucial, and therefore the son's claim failed, even though there was the clearest possible notice and so on. So it doesn't matter that there is generally the equitable doctrine notice. In many modern systems, it's superseded in the interest of clarity to get away from the blurred edges of constructive notice, you see. And that's the possibility here that we're looking at.
You see also, Mr. Nanda, it's not a question of either it applies in this case or it doesn't apply in any case. There is a difference. If the issue is raised in the context of an opposition to an application for a transport, then it may very well be highly relevant, that doctrine. And if it is held that there is the second purchaser gave value without knowledge of the first one's interest, I don't know. It may be that he might be allowed to obtain the transport. But in a situation where the transport has been passed to the second purchaser, and it's a question of divesting him of it, you've got to establish first of all that there is a possibility of divesting him, that there are circumstances which entitle you to do that.
But, Your Honor, the circumstances here are very clear that Mr. Ali Mohammed took transport with notice of Ramdass's sale.
Yes.
And that Ramdass paid the full purchase price, that Ramdass was in possession. So those are not circumstances that are in dispute. The trial judge accepted those as findings of fact. The Court of Appeal stamped its imprimatur to it. And so that, Your Honor, and I submit that that is fraud.
That amounts to fraud, you would say?
Yes, yes, Your Honor.
Notice?
Having regard to what is stated in Alicock against the Demerara Bauxite Company Limited, which I have a citation there, it doesn't involve, no degree of moral turpitude is necessary to establish fraud within that section.
Surely there should be some collusion between the vendor and Mohammed.
But clearly there was. Look, he must have known that she sold the property to her brother and is selling it to Ali Mohammed. Clearly that is an inference that any court of law will be compelled to draw. So that, Your Honor, in that factual matrix, I will invite Your Honor respectfully to find that fraud was established. And of course, I quoted that book, An Equity.
What are the particulars of fraud? Is that pleaded somewhere?
No, well, the unfortunate thing is that that was not done.
Well, how do we know what fraud you are relying on, other than you're saying it's about notice?
But that's the fraud, it's the notice.
And more important, how did Ali Mohammed know what fraud you were alleging, or that you were alleging this as constituting fraud, particularly in the light of the express withdrawal of it?
Well, Ali Mohammed's lawyer had Mr. Anamaya's submission. And from the beginning of the case, Mr. Anamaya was arguing fraud.
Well, actually, the statement of claim in paragraph 17 did allege
Fraud.
fraud.
So that there was
But
notice.
you gave no particulars of it. You just said that the transport was fraudulently passed.
That's correct.
But no particulars of the fraud were given.
But the particulars are clear on the record.
You said the transport was fraudulently passed,
Yes.
and that's it, before the judge or before the registrar? What do you...
Was passed, meaning that when Ali Mohammed received this transport, he received it
From the registrar.
by virtue of fraud, and you receive it.
It practiced upon the registrar? I mean, what do you mean by fraudulently passed transport?
I mean that Loki, knowing full well that she sold the property to Ramdass, and Ali Mohammed knowing full well that Ramdass purchased this property, that Ramdass is in possession of this property, that Ramdass has paid off the full purchase price of this property, accepted transport.
But I think, though, Mr. Nanda,
And those are facts that are clear in the record.
this paragraph 17 is not worded very clearly, I must say. It says that the first name defendant and the second name defendant's owners, in order to defraud the plaintiff of the said property, the first name defendant fraudulently passed transport on the 5th day of May by the registrar of deeds
One moment.
in favor of the second name defendant.
But Mr. Nanda,
Yes,
whatever may have been alleged in the statement of claim, when we get to the trial, an attempt is made to supply particulars of that allegation of fraud. The judge apparently held that the application came too late. And whereupon counsel for the plaintiff said that he was withdrawing or he was abandoning the allegation of fraud. Now, whether there was evidence that might have constituted fraud, surely, in all fairness to the respondents, they would have been entitled to know that the allegation of fraud was being persisted in, and that this evidence of entering into an agreement with knowledge of the prior one was being relied on as evidence of their fraud. They were entitled to know that, so that they could have had the opportunity, perhaps, of adducing other evidence which might have shown that while the notice may have been constructive in the case of certainly of the second respondent, of Ali Mohammed, that it was not, the circumstances were not such as would justify a finding that he was fraudulent.
Your Honor, if a perusal of the evidence on the record is done, Your Honor would find that the cross-examination of both Mr. Anamaya and Mr. Mursaleen Bacchus, who appeared, were all centered in that direction. On the question of fraud, fraud became a live issue at the trial, notwithstanding the fact that it was removed from the pleadings. And when you look at the submissions of Mr. Anamaya, you see that fraud forming a central part of that submission.
Submissions to whom?
To the High Court judge as well as to the Court of Appeal.
Well, the submissions at the end of the case.
The submissions were at the end of the case, yes.
But I thought that there were especially strict rules when you were alleging fraud. And the rules were particularly strict. And you had to give particulars. And apparently counsel recognized that. And how can he turn around, having withdrawn his allegation, having not thereafter pursued the matter of particulars, and then turn around and say, well, notwithstanding all of that, the case should be decided on the basis of fraud?
Your Honor, I cannot justify counsel's withdrawal of fraud from the record. I don't know. If I was in his position, I would have, even if the judge said it was too late, I would have insisted and let him overrule me.
Yeah.
And that would be the basis of my appeal as well. But that did not happen, and I cannot change that. But all I am saying, all I'm trying to persuade Your Honor, is that fraud having been withdrawn, it was only an academic exercise, because fraud remained an extant issue throughout, a live issue throughout the trial and in the Court of Appeal as well. And I'm trying to introduce it here.
Describe what they were debating as an issue of fraud?
Sorry?
Did they describe what they were debating as an issue of fraud?
Yes, my lord, Mr. Anamaya said he had submission headed fraud.
No, I'm not on the submission. I mean, you said that there was evidence going before the court.
Yes, please.
Examination about fraud.
About fraud.
And was fraud actually put in the evidence?
Put in cross-examination?
Yes, in fact, Your Honor, Mr. Bacchus cross-examined.
Would you refer us to the point at which he put fraud to the Ali Mohammed?
I may not be able to do that right now, Your Honor, but
Well,
I can mark it up before I
look
leave.
for it, but I have to stop you now, Mr.
Very well, Your Honor.
You're 15 minutes over your time, I'm afraid.
Very well.
We thank you very much.
Thank you very much, Your Honor.
Yes, Mr. Budai, can we hear from you now?
Cashier.
Oh, Mr. Cashier can, I'm sorry.
May it please Your Honours, pursuant to the invitation, the kind invitation of the court, myself and my colleagues have prepared a brief in response to the issues that have been outlined to us. And with your permission, Your Honours, I wanted to begin on what appears to be one of the central issues that has addressed this court, and that is an interpretation of Section 3(1)(d) of the Civil Law of Ghana Act. Your Honours would note that there were two authorities cited, and that is first the authority of Jupiter Singh versus Raymond Bain, and that is found at pages 67 to 91 of the Index of Authorities. And I wanted to refer Your Honors to, in particular, page 79 of the record. Because in that case, I believe Chancellor George pursued an analysis of the very point which has previously addressed the court. And if I might read from that particular, it is on page 13 of his judgment, page 79.
Yes.
And he says, and I quote, "As it is well known, the principal reason for the enactment of the Civil Law of Guyana Act was to replace the Roman Dutch law by the English common law, together with the doctrines of equity, except as regards certain aspects of the law relating to immovable property. This significant exception aside, Section 3D expressly provides that the English law of personality shall govern both movable and immovable property, and Proviso 1 specifically excludes inter alia," and he quotes the same section, "any incidents attached to land." He further goes on to say in the same paragraph, Your Honors, that it is counsel's contention, as in Williams and Greatrix, describes the purchaser who has been put into possession before completion as possessing an equitable interest in the property, as there is no similar or comparable interest attaching to an agreement of sale of personal property in England. It was not open to the trial judge to rely on the rationale of that case and hold that the respondent had an equitable interest. As I understand the position in England, the effect of a contract of purchase of sale is to pass the equitable interest in the land to the purchaser, and this does not depend on putting him in possession. And then he quotes Cheshire 6th edition. He then goes on to say, quote again, "I am inclined to the view that counsel is right, and the concept of an equitable interest in the purchase of land is precluded by Proviso 1 of Section 3 of the Civil Law of Guyana Act. And the draftsman of the Act must have realized the consequence of this circumscription, as it would relate to the applications of principles of specific performance to contracts involving the sale of immovable property. Therefore, another proviso, Proviso 3, was included, which expressly provides that, and quote, the relief by judgment of specific performance shall be granted in the case of immovable property on the same principles upon which it is granted in England in the case of contracts relating to land or interest in land." Your Honor, apart from that section, I wanted to also, with your permission, point you to another piece of analysis that was done by Chancellor George on the very section in Fazal and Adamantadou, which is contained between pages 92 to 98 of your Index of Authorities. Pages 92 to 98.
That's the judgment of Liverpool. That's his
Dynasty.
Chancellor George, please, Your Honor.
I think our copy goes from 91 to 99. I think that's a problem. Yeah.
Mine is like
It's
Yeah, 110. Yeah, yeah. This is Article. I don't have paragraph. I read it sometimes.
I refer Your Honours to page 158 of the judgment at paragraph F. In which Chancellor George says the following, and I quote, "Further, under provision 1 of the section, removable property was not to be subject to any of the incidents attached to land tenure or to estates and land in England, which were not attached to personal property, except that in the equitable relief by way of specific performance was to be granted in case of immovable property on the same principles on which it is granted in England in contracts related to land or interests in land." And I believe, Your Honor, the seminal aspect of this particular quote, Chancellor George goes on to say, although there have been isolated dicta to the effect that equitable interests can be created in the land, see for example Ishri Prasad versus Jairam, the overwhelming body of judicial opinion is of the view that express trusts apart, equitable estates or interests are precluded by the above provisions. And he goes on to quote some of the more known authorities, for example, British Colonial Film Exchange versus SS De Freitas, and the passage that is contained there. As it relates to the issue of the registered interest of the agreement, the other aspect of this case, which I believe should attract the court's attention, is that the facts of this particular case are that there was a piece of land that was owned and given to a real estate agent to sell. Unknown to the real estate agent, the owner of that land had sold two smaller parcels which constituted part of the same land. The persons who purchased those two smaller parcels went in the same direction as has been advocated by Madam Justice George in accordance with Section 7F and registered those interests. Nonetheless, the court held, Chancellor George held in these circumstances, that it was still open for the agent to advertise and consequently sell the property as being, quote, free from all encumbrances. And this is what Chancellor George had to say about that particular matter on the following page. And I refer Your Honours to paragraph D, where he says, where therefore the definition of registered interests are made to include rights and interests imposed or attached to immovable property by agreement or otherwise, it could not have been referring to the registration of an equitable interest such as a contract of purchase and sale. What is envisaged in the registration of legal interests or liabilities are such as easements, profits upon, and servitudes, and not what may be considered to be estates or interests in land, whether of an equitable or legal nature. And he goes on to say this, which I believe answers one of the issues that was raised. But if I would have been constrained to hold otherwise, it is my opinion that by giving the agent a copy of the transport which was devoid of any annotation of either of the two contracts, and I would wish to pause there for a minute, Your Honours, because apart from being Chancellor, he was also, Chancellor George was also one time one of our most experienced Registrar of Deeds. So he headed the section. And he's saying in this judgment that it would appear that upon registering the contract of sale, an annotation could have been made on the transport which would have put anyone who now seeks to sell the land in its entirety on notice that there is a contract which is now part of the records of the deeds registry.
So, could you explain to me how were these agreements for sale registered? I mean, there was
in the same manner as was outlined
there
by
was no annotation on the transport that there is registered here. they are registered. He had 2 agreements for sale dated so and so.
Apparently what took place from what is indicated in the record, Your Honor, is that the agreements were registered in the deeds registry, but no annotation was made on the transport itself, which, from what Chancellor George is saying, ought to have been done, which will then put the agent on notice that when he chooses now to sell to any prospective third party, that as is common practice, when you wish to buy a piece of land, one of the first things you do is you ask to see a copy of the title deed. You would see this annotation written across the front of it, which says...
Whose fault was that? The registry, or... I mean, you're saying that had there been an annotation, as there should have been on the transport, then that would have solved the problem. Is that what you're saying?
I'm saying, sir, that Chancellor George is advocating that as one of the possible methods by which notice would have been given to any prospective third party.
So that coincides with what we were discussing earlier in relation to registered interest.
I believe so, Your Honor, in accordance with Section 7F.
Although he said earlier in the paragraph that they could not have been referring to equitable interests such as a contract of purchase or sale. But if it is registered, at least it's notice to any subsequent purchaser that there is a prior contract or agreement.
Contractual interest.
So, Mr. Khan, if a contract of sale is registered and there's an annotation made on the transport and X, the whole of the transport with that annotation passes the transport, or can that person pass the transport to X third person, completely contradicting or without giving effect to that annotation? One, is that possible? And two, if it is possible, does the person who obtains the transport take that transport subject to what is contained in the annotation?
I would think, Your Honor, that as regard to your second question, they would take subject to whatever contractual rights may have accrued on the transport prior to obtaining the legal title. As it relates to the first question, Your Honor, I believe that notwithstanding and given the dearth of dicta in this particular area, that such a transport can pass to effect legal title to a third party.
Isn't there a role for the Registrar of Deeds? Because it was the contracts were registered, were they not?
Yes, in
Although
Fazal and
not
Adamatu.
annotated on the transport.
In this case, apparently, there were not.
No, but isn't there no role for the Registrar of Deeds to, he or she knows about these contracts, should know?
Ought to know.
Ought to know.
Yes. I believe what Chancellor George is advocating in this particular passage is hypothetical, because he did say, having established that clearly there are no equitable interests, he then goes on to say, but if I were to hold otherwise, even in those extenuating circumstances, at the very least, there ought to be some annotation on the transport.
Listen, that is what he would have done when he was registrar of...
I would believe that is how he would have handled the matter.
But this seems never to have been put into effect.
In my experience, Your Honor, no.
His main paragraph at 159D seems to indicate he doesn't think these rights can be, these rights under a contract to buy land can actually be registered as interests, on the basis that if they are, then they must affect third parties, because under Section 22, you must take subject to registered interests. So since these he regards are not capable of being equitable property interests, capable of binding third parties, it follows they can't be a registered interest, because registered interests are those that are imposed on immovables or attached to immovables, whereas the contractual right against the vendor is just a personal right affecting the vendor.
That would be an accurate statement of the position, Your Honor.
But I don't see how then there's the power to affect third parties by making an annotation derived. Where is that power come from?
Your Honor, that would go back to and I wanted to point, Your Honor, in the direction of a case which I didn't have an opportunity to append, and it is found on page 21 of Dalton's book on registration of title. And the case is that of Mangia versus Safayan and others, 1917 LRBG.
Where is it? Do we have it?
No.
How do you spell it?
Mangia, Mangia,
Yeah.
versus Safayan and others, Safayan. And it's to be found at 1917 LRBG, page 58. And Dalton's note on this particular
You have
case.
copies?
Yes, please. And in that case, Your Honors, it was held that a purchaser of immovable property who has not obtained transport of such property to himself.
But Mr. Khan, we don't have photocopies. We thought you had photocopies. You don't have photocopies, do you?
No, sir, I don't have photocopies.
I have the case. You have it? Yes, I have the case. So.
It's.
I think I was able to look at
Oh, sorry, you have it on the screen. I see. Okay, thank you.
And a copy of the book is with you.
Yes, it's all right. I mean, it's on the screen.
It says, and I quote, a purchaser of immovable property who has not obtained transport of such property to himself has but a use incorporate, that is, the use ad rem to demand and obtain transfer from the seller. Such use incorporate cannot be taken in execution by a writ to attach the immovable property in respect of which the use existed. In other words, Your Honor.
That's the case itself.
Yes, please.
You do. Okay.
This is a sale at execution, a judicial. What is Mangia and Safayan about? It's not an ordinary straight agreement for sale and sale. Sale at execution. That's what it is.
Yes, please, Your Honor. But in this case, it was a competition between a judgment holder's interest and the interest of someone who had purchased the property.
Let's say we take a vendor and a purchaser. It's saying that you can't, although the purchaser has a particular right against the vendor, you don't have any right to attach the immovable itself. All the purchaser has is the right to sue the vendor to get specific performance and in the end get the property. But it's only a personal right that he has.
Which is consistent with the fact that this is an equitable, this is a remedy in equity which acts in personam, as opposed to attaching itself to the property, which is the subject matter of the agreement for sale.
Yeah. And there's no possibility of attaching any extra interest of the purchaser. You can only attach the legal estate, the legal title to the immovable, or not at all. There's no halfway house.
No halfway house, according to our reading of the authorities, Your Honor. With regard to the first issue, Your Honors, the only circumstances which we found, and again, it was a quote that we did give to Your Honor, where a binding contract can be specifically enforced against a subsequent purchaser would be the exception that was outlined in Fazal and Adamantulu. That is in the case of an express trust. We also pointed, Your Honors, to a recent decision of the Guyana Court of Appeal in which Justice of Appeal Ramson, in a majority decision, appeared to suggest that in certain circumstances a trust might be implied. But at the same time sought to circumscribe that implied trust in circumstances where a fiduciary relationship or an informal arrangement in a family setting occurs.
Yes, well, if we actually apply the law relating to personal property, you can have trusts of personal property, can't you? Whether express trusts or resulting trusts, like a resulting trust of a ship in the venture, a Court of Appeal case, or constructive trust of a houseboat where people live. In a case, in a recent case in England. So on that basis, you could argue that you can have express, resulting, or constructive trusts of personal property, of movables. But of course, where land is concerned, then there is a problem because of Section 3 in the proviso in the Civil Law Act.
Yes, please, sir. And Section 3 also includes the equity in relation to personality. The other digression as it relates to this particular aspect, I wanted to point out to Your Honors, where a very subtle but in our considered view a very important distinction was made was in the judgment of Chancellor Bernard, as she then was, in the case of Chandra Narayan Dubey versus the Attorney General, to be found at pages 32 to 53 of your record. This was a case that essentially concerned state land. And the judgment deals with two issues which, in our view, touch and concern the matter at hand. And at page 42 of your booklet, page 11 of the judgment, the last paragraph, and I quote, "It has been postulated that since it has been held that equitable interests are not recognizable under our law of immovable property, the principles of equity ought not to be applied. I wish to point out that there's a difference between conferring equitable interests and utilizing principles of equity to confer legal rights." So that there may be avenues with the use of, and in this case there was the issue arose of proprietary estoppel. And the court in those circumstances held that the application of the legal principles served to give the appellant in this particular matter an equity which the court then gave effect to as distinct from an equitable interest.
How do you apply all of this to the incident case?
As it relates to the first issue, Your Honor, we believe that the issue of both expressed and implied trusts are not part of the factual matrix. But we sought to answer the issues in an open-ended way simply to give you what may or may not be the options. As it relates to this particular circumstance, it is our considered view that having regard to the evidence, there is no question of implied trust or an express trust. And therefore, it does not, in our view, fit into one of the exceptions, which would then allow the first purchaser to enforce the contract as against the second purchaser. That would be our response to issue number one. There are circumstances, but they don't apply on the factual matrix that is before you. As it relates to the second issue, Your Honors, we have submitted that the application of the doctrine of notice, and along the same lines as Your Honor has pointed out, has to be circumscribed by the fact that it is clearly understood in the context of Guyana that the only interests recognized inland are legal interests. And in this regard, I wanted to make the analogy between what we have as the transport system at the moment and the torrent system, which is the system of registration, where it is a basic principle that once a title to land has been registered in the register and a certificate of title has been issued, in accordance with the mirror principle and the curtain principle, the only right anyone has to any sort of redress or relief would be in accordance with damages. In other words, that the register is at some level inviolable, and that the only remedy as against anyone claiming would be in respect of damages. This was also a point that was borne out by Mr. Justice Loku in Kitty.
Is there not an exception in the case of fraud under the torrent system?
There are a number of authorities, please, Your Honor, which would suggest, and they originate out of New Zealand, I don't have them with me, that involved the use of land that belonged to the original natives of New Zealand, the Maoris, which were supposed to be ancestral lands. And during the colonization of New Zealand, that land was taken by the authorities at the time and then given to other persons. The court held that notwithstanding that that land actually was ancestral lands, the only thing that was available to the native councils was that the government was required to pay them compensation and not to give them back. They were not entitled to get back the land. And that is consistent with the torrent system, where part of what you pay when you register a conveyance under the torrent system goes to something called the consolidated fund. That is part of the series of charges. And part of the function of the consolidated fund is to ensure, in the event that title has been obtained in a less than transparent means, there is redress by way of damages for anyone who so complains. That is complete an aside, but I draw that to your attention, Your Honors, to indicate that the transport system that we have in Guyana at the moment is in some respects parallel and is in sync with the torrent system as it is practiced not only in Guyana, but in other parts of the world. As it relates to the third issue, please, Your Honors, whether or not the notice was actual or constructive, it is our submission that unless it was in the form...
You were referring to a judgment of Laku. Oh, yeah, you were just giving the reference, or what?
I was just pointing, Your Honors, to the dicta of Laku in Kitty Village Council versus Vera, and subsequently the dicta of Chancellor George, at the time he was Justice George, in Dan Paul versus Demerara Bauxite Limited, to be found at pages 116 to 122 of your record.
City Village Council was in your bundle.
The quote is taken from Sing and Bain, please. George.
Is Dan Paul referring?
Dan Paul.
What is the reasoning? We referred to dicta and so on. But what is the rationale of the, how do they construe the words of that section so as to rule out equitable interest?
It would be along the lines, Your Honor, of the section being read not disjunctively but conjunctively, whereas the "and," as was referred to earlier in the arguments, suggests that issues of primogeniture, male to female, and incidents of land tenure and other incidents are to be read, use them generous. And that therefore the instances which are in these circumstances do not apply. The other issue that is to be noted here is that Chancellor George referred to it as an exception in the passage that was quoted earlier in Sing and Bain, 3.1d, that it is an exception, and that therefore, outside of those circumstances, it does not apply.
How do you mean it's an exception? Out of what circumstance?
I refer to, Your Honor, to 3.1. Provided that.
Yes, read it. Go ahead.
Immovable property may be held as heretofore in full ownership, which may be the only ownership of immovable property recognized by the common law, and shall not be subject to any rule. In other words, that any of the rules that are applicable in relation to primogeniture, males to females, incidents attached to land tenure or estates in land are not attached to personal property in England shall not apply.
Yes, but does that include equitable interest?
The interpretation given to that by Chancellor George in Sing and Bain indicates that it does not apply to equitable interest.
It does not apply. I thought he held that it did apply. It did include equitable interest, and therefore they were not permitted. Is that not the reasoning?
See?
It just seems an odd family. The primogeniture, equitable interest.
Page.
This is the example of the
I refer you on to page 67, which was quoted earlier.
Okay. 67.
of the record.
Of the index, page 70.
67 is Group P.
Same versus Raymond Bain.
At page 70, you're talking about.
Yes.
To be found at page 80. Which Chancellor George says, and I quote, "I am inclined to the view that counsel is right, and the concept of an equitable interest in a purchase of land is precluded by Proviso 1, Section 3.
It does what?
It precludes an equitable interest to a purchaser in land.
Right. How firmly is that established in Guyana law?
In that regard, Your Honor, I would refer you to the most recent decision. That is the decision in Keith Collymore and Ina George, to be found at pages 1 to 31. And I would refer you, Your Honor, first to the majority decision of Justice Appeal Ramson.
But I think that goes back to Kitty Village Council and against, that was the
Yes, please, Your Honor. And
Council of Weeks first.
at page 21, when Justice of Appeal Ramson quoted Kitty Village Council versus Vera.
Yeah, that's what he's saying.
And Justice of Appeal Ramson goes on to point out that apart from the exception of express trusts,
That's at what page? Yes, maybe 22, the top of 22. Page 10 of the judgment.
I think he was just quoting from Justice Chancellor George's judgment in Group T and B, in which you had referred us to earlier.
and I would want to refer, Your Honor, also to point out that notwithstanding that there were two dissenting judgments in this particular matter, a dissenting judgment as well as the main judgment, both Chief Justice Chang at page 6 of your record says, and I quote, there are two lines of cases on whether in Guyana there can be an equitable interest in immovable property. The weight of the more recent local decisions favors the proposition that express trusts apart, there can be no equitable interest in immovable property. Notwithstanding that Chief Justice Chang disagreed with Justice of Appeal Ramson, this very point was
In agreement.
Was what?
was reinforced in the judgment of Justice of Appeal Ramson. There was no disagreement on this particular point.
But
And I refer you on to page 25 of your.
But I think the cases listed in Justice Chang's judgment, these all reaffirm the fact that there are no
Equitable interest. And if Your Honor were to look at page 25 of Justice of Appeal Ramson's decision, 13 of his decision, but 25 of your decision, of your index. And Justice of Appeal Ramson says, about halfway down the page, it is in this context that the pronouncement of George C. with respect to an express trust cannot be faulted. To do otherwise would be a damning and unpardonable indictment of the learning of this great jurist, and would erode without just cause the great esteem in which he is held. So in response to your question, as far as the recent authorities go, as recent as this one, even though there have been disagreements on other matters, there is no disagreement generally that there are no equitable interests in land in Guyana.
Well, what was the last expression the other way?
There have been decisions at first instance, and they were quoted by my learned friend in the article by Mr. David de Carey's. But those decisions seem to more or less touch and concern issues where a wife, and you would notice the first paragraph of that particular article, and it is up on your screen. It begins, if a wife has contributed to the purchase of a property, title to which is in the name of her husband, does she have an interest in the property recognized by law which she can assert against a mortgagee who has taken a mortgage on the property from the husband as security for a loan to him? The answer to this question depends on whether equitable interests in land exist in Guyana, and if so, whether the wife could lose her rights if she failed to oppose the mortgage. The concluding paragraph of that particular article, Mr. de Carey's points out, and I quote, "It is my opinion, therefore, that even if the courts are willing to recognize the equitable interests of the wife, mortgages would be protected from any claim by a wife to an equitable interest in the property mortgage of which they have no notice at the time of mortgage. Are they under duty to inquire about the existence of such interests? I would submit, once again, that as the old Roman Dutch law of mortgages has been retained, equitable doctrines have no place, and the mortgagee is entitled to rely on the mortgager's title or transport and is under no duty to go behind it looking for equitable interest."
So there he is agreeing with the general view.
The general view, that essentially, that the title, as quoted in section 22, gives full and absolute.
But I don't understand, even if the passage begins, even if she does have an equitable interest? Is that how it begins?
Yes, that even if the courts are willing to recognize the equitable interest, because what has happened?
I think that if they recognize that, then there may well be a duty to inquire.
The submission of Mr. de Carey's of this is that once the old Roman Dutch law of mortgages, and this is in relation to mortgages, where in Guyana there is a condemnation clause where a mortgage is essentially a judgment in rem, which is only waiting to be executed in the event of default of payment. And he's referring to that situation and says that as the old Roman Dutch law of mortgages has been retained, equitable doctrines have no place, and the mortgagee is entitled to rely on the mortgager's title or transport and is under no duty to go behind it looking for equitable interests.
That is in the context of mortgages.
Mortgages, yes, please, sir.
I think we are not really looking at it in that confined context.
I mean, what would be the position if the husband sold the house? Would the purchaser take subject to the wife's interest?
I believe generally in Guyana we would follow the position as outlined in the English case of R.V. Etheridge. And which is that unless the wife obtains a certificate of and it has become the practice in Guyana now, where spousal property is about to be mortgaged, the banks would require that even though the mortgage is going in the name of the husband, that the wife goes to an attorney, be advised as to the implications of the mortgage and the fact that she can lose her property and the attorney is required to issue a certificate of independent legal advice, whereupon the bank then proceeds to release the money and register the mortgage.
But doesn't that, does that involve an unwillingness to rely on De Carey's view of the law?
I would submit that as it relates to Roman Dutch mortgage, I believe that Mr. De Carey's exposition is accurate. But as it relates to other circumstances, I believe that, especially in light of the passage of the FDPA in Guyana, the Family Dependence and Provision Act, some modification of the law as it relates to when it was formally administered under just Deeds Registry Act and the Civil Law of Guyana Act has been engendered. In addition to which, it is our considered view that, having regard to some of the interests that have arisen in relation to spousal property, there may be some latitude. But the course has always been, the preferred course, if I may, has been along the lines as espoused by Chancellor George, as she then was, that notwithstanding, Chancellor Bernard, my apologies, as she then was, in Chandra Narayan Dubey, where notwithstanding that there are no equitable interests, legal principles can be adopted to convey an equity as distinct from an equitable interest.
Are there, apart from Mr. De Carey's article here, are there any other cases which went the other way, recognizing that there could be equitable interest?
There's a case of Obomala and Obomala, which is quoted in the De Carey's article.
De Carey's is not arguing against George's theory, is he?
No, please, Your Honor. He is reinforcing it as it relates to Roman Dutch law, and especially as it relates to mortgages. Our research indicates that there has never been a Court of Appeal decision which has gone the other way in relation to not recognizing that there are no equitable interests in land. There have been some decisions at first instance, but never at the appellate level.
Does Dr. Ramshaw in his book, does he take a side on him?
Dr. Ramshaw has adverted to the fact that, and one of the reasons he postulates is the fact that many of our judges have been English trained and do not have the training that is necessary to properly apply and interpret Roman Dutch law. And I do believe that he has suggested that over the passage of time that maybe the practice has evolved that may allow for some recognition of equitable interests. But our more recent Court of Appeal decisions would suggest otherwise.
At the moment, the position seems to be rather uncertain and messy, primarily due to this rather ambiguous Civil Law of Guyana Act. It may be that what needs to be done in due course is to recognize that there isn't just one variety of trust, the basic English trust, which is the proprietary trust with a full equitable interest in property capable of binding third parties, which is a classic trust. There's also what you might call the obligational trust, where the obligation is not capable of binding third parties. It just binds the trustee, but it also binds the trustee's creditors. So that if the trustee becomes insolvent, the property doesn't go to the creditors generally, it's preserved for the beneficiary. And it may be that you have to have an obligational trust as far as immovables are concerned because of the proviso 1 to section 3D. But where personal property is concerned, maybe you can have a full property trust. So you have a halfway house for dealing with a mixed civil law and common law jurisdiction.
I believe, Your Honor, I completely agree with that. I believe that is where Justice of Appeal Ramson appeared to be heading when, having reaffirmed that express trusts are the only accepted derogation, he then went on to point out, and he quoted in his decision, at page 19, quoting Justice of Appeal Bishop in Collymore versus Gomes. Says, in an appropriate case, those who administer justice must not be reluctant to shed their judicial restraint to provide a remedy or solution. It is why in our submissions, Your Honor, we pointed out that it appears as though this decision opens the door somewhat to implied trusts in certain circumstances. So as a way of providing means, but the implied trust in these circumstances were circumscribed by the existence of a fiduciary relationship which comes out of Soar and Ashwell, or where there's an informal family setting, as was pointed out by the learned authors in Pettit on trusts.
Well, we are grateful to you for dealing with the subject, broadly. But it does seem as though it probably was not necessary for us to investigate the question of whether there can be any equitable interest created under a trust in Guyana. I think that the question which this case poses doesn't really include that, as you have submitted, that there is no question of any form of trust in this case. Really concerns the issue of whether or not an equitably estate was acquired by the appellant as a result of this transaction of sale and purchase.
Yes, please. But like I said, we sought to present the issues in the broadest possible way, and we would be happy to respond to it in the instant circumstances. As indicated, there appears to be no trust in this situation, so that the answer in relation to issue 1 would be that it does not appear in the instant circumstances that the first purchaser can specifically enforce the contract as against a subsequent purchaser to whom transport has been passed.
Even though it was passed in circumstances in which, both at the time when that occurred and at the time when the contract which founded his right was made, both parties knew of the earlier agreement.
That would be our position, sir. And I wanted to...
So that you accept that, one has to accept that under Guyana law, it is possible for unscrupulous people to pull a fast one, as we say, and get away with it.
It would be possible, indeed, in these circumstances. But I wanted to...
I don't think it's only possible. It actually happens repeatedly.
I suppose it is also obvious that if there were equitable estates in Guyana in these circumstances, that would prevent the scams from succeeding.
I would respectfully submit, in accordance with our own maxim, strict to the government, wise to the population, they would probably find some other way to.
That one?
That's
Find a way around it.
Yeah. Well,
I,
that is in the nature of scams, but
indeed, sir. Your Honor, I wanted to just point you also in the direction of the dicta of George J., as he then was in Dan Paul versus the Marbach site, to be found at page 126 of your index.
156.
126. Page 205.
Yeah.
It's page 106, I
Is
think.
it? 116. That's 116.
106 is George J.
King is Simon.
117 is Lucky J.
But mine starts with 116.
Dan Paul.
That's where it starts.
Mr. Clark, is it Alicott and Demerara or Dan Paul and Demerara?
Dan Paul and Demerara.
Demerara, right. That's page 116.
At page 120 of your
120. That's a judgment of Justice Lockwood. Is it just the Georgian decision or?
My apologies, Your Honor. This is the judgment of Lockwood J.
Yeah.
At page 265 of that judgment, at paragraph H.
Paragraph. Page 1. 269. Page 1. 265 of the judgment itself.
After analysis of the cases, Justice Lockwood points out as follows. But there is no provision which required the tenant's interest in any of these cases to be registered. The object of registration of a lease under the Deeds Registry Ordinance is to give notice of the existence of the lease to, amongst others, a purchaser of the immovable property in respect of which the lease has been granted. Unless reserved by the conveyance itself, interests in immovable property which are required to be registered, if not registered, are void against the purchaser even if he has actual notice of those interests. This is so in this colony as it is in England.
Perhaps I might add, in England, it's assisted by Section 199 of the Law of Property Act 1925, which says a purchaser shall not be prejudicially affected by actual notice of anything void against him for non-registration. But as you say, Lucky J suggests that you still have that net effect under the Guyanese legislation, even without that provision.
So that as it relates to issues 3 and 4, 2, 3, and 4, the dicta of Lockwood J suggests that even if the purchaser has actual notice, and this was in the case of a lease, which is a far stronger contractual position, if I may say so, than someone who simply is purchasing. Lokuj is suggesting that even if he has actual notice, it does not preclude the passing of transport.
Is that because of the Civil Law Act or the deed registration?
In the previous page, Your Honor, he quotes subsection 1 of section 23 of the Deeds Registry Act. And that is the point from which he starts the analysis. On the basis of 23.1.
Yeah.
Finally, Your Honor, I wanted to deal with issue 5, the issue of fraud.
Yes.
And as has been previously indicated, apart from the bare statement in paragraph 17 of the statement of claim, fraud was not particularized. And it is our submission in those circumstances that there was not an opportunity of the respondent to test the evidence as it relates to fraud and what was the nature of the fraud that was being postulated. And in that regard, I would direct Your Honors to Leon van Slytman versus New Building Society and CJ Thrift Shops, to be found at pages 54 and 66. In which Justice of Appeal Bernard, as she then was,
This page 66, fraud must be specifically pleaded and proved.
yes, please, Your Honor. At page 66.
What case is it?
It's number 3 and that's like
Yes, 66. And the statement contained there is, and I quote, "The second ground of appeal suggests that there was an allegation of fraud. A perusal of the statement of claim does not reveal any particulars of fraud or even a suggestion of fraudulent conduct on the part of any of the parties. Fraud must be specifically pleaded and proved. In the absence of any such suggestion, this ground of appeal must fail."
Would entering into the second agreement with knowledge of the first constitute fraud for the purposes of the Act?
Your Honor, our review of the authority suggests that it would not. And we would go all the way back to Fazal and Adamantulu, in which the agent notwithstanding that there were two agreements of sale for smaller parcels of the same piece of land that were registered. Chancellor George, in that particular case, held that it was not a fraudulent act for him to say in the agreement of sale that he was selling to the third party, that he was selling, quote unquote, free from all encumbrances. Because in accordance with the decision there, that it was not a registered interest in accordance with the definition of registered interest. And therefore, for the agent to represent on behalf of the principal that he was selling this piece of land, quote unquote, free from all encumbrances, was not something that he was not entitled to do.
It was true, wasn't it?
Yeah, that it was accurate.
Yeah.
There's the passage you cited from Dan Paul, again from Mr. Justice George, suggesting that in the light of the deeds registry ordinance, even if you had actual notice that the transport would
be unaffected. Loku in Dan Paul.
Yes. It was Loku J. Yeah.
I first said George J. My apologies. It's Justice Loku.
Although in a situation where the first purchaser would oppose the transport, he could succeed. Correct?
Correct. He would more than likely succeed in those circumstances under the facts that we have before us. But it would not be fraudulent for the person to say, I am selling you this land, quote unquote, free from all encumbrances, because the nature of the agreement was not a registered interest as recognized by 23(1).
If the purchaser, because he wasn't sure of his possession, he gave a check which he intended to stop in order for the balance of the purchase price, in order to get the transport. Would that be a fraud?
It may amount to fraud in those circumstances, Your Honor, but that is at best uncertain, given the fact that there was no particulars in the statement of claim. There wasn't an opportunity for it to be tested. I think that would...
Well, that certainly was not alleged as fraud.
As a result of the uncertainty of the fraud, we wanted to point Your Honor's attention to Chief Justice Chang's decision in Collymore. Because in that decision, Chief Justice Chang had to grapple with a somewhat similar situation. And that is to be found at page 8. In the particular case on the review, there was an allegation that the transport was obtained under fraud. In this case, it was what is known in Guyana as a Section 35 application, where permission for sale was obtained. And Chief Justice Chang had this to say at page 8. Where the appellant obtained transport in his name, he obtained a transport order under an order of court. Since the transport was passed in favor of the appellant on the strength of such order, which the appellant had obtained from the High Court, the High Court order could only be set aside by a court of coordinate jurisdiction if the court of coordinate jurisdiction found some collusive or unilateral fraud upon the court. And in that regard, he quoted the dicta of Loku CJ in Adams versus London. Normally, to have judgment set aside for fraud, there must be collusion. However, a judgment can be set aside if obtained by unilateral fraud upon the court. And further on, goes on to quote Lord Justice Rolt when speaking of the nature of the fraud. In Patch versus Ward, Lord Kane said that the fraud must clearly, as it seems to me, be actual fraud, such as there is on the part of the person chargeable with it. The malus animus and malus mens putting itself in motion and acting in order to take an undue advantage of some other person for the purpose of actually knowing or defrauding him. What is also noteworthy is towards the end of the section is the quote from Lord Justice Rolt, in which he says, however, it will be noted that the judgment will not be set aside merely on the grounds of perjury or falsification of evidence. So that it would suggest that there are two species of fraud perhaps that we're dealing with here. That is either collusive or unilateral fraud. And given the difficulties as previously outlined that we don't know exactly what was being specifically pleaded, we have chosen to analyze it in the context of both, whether or not there was either collusive or unilateral fraud.
You would say here it's not fraud to take advantage of legal rights. And it's just a straightforward taking advantage of legal rights in this strict system of property law.
I would even go further and say it may amount to professionally maybe a sharp practice, but beyond that, I would agree with you that it's simply a matter of taking advantage of what is the legal position.
Yes, anything else, Mr. Khan?
One other, I wanted to refer, Your Honor, to paragraph 19, because this appeal raises the question of fraud at this stage, when it would have been dealt with prior to that. And I wanted to refer to Your Honor to the dicta of Chancellor Bernard in Chandra Narayan Dubey versus the Attorney General. It's to be found at pages 32 to 53.
Once again.
In this particular case, the issue of estoppel was raised for the first time in the Court of Appeal. And the Court of Appeal then had to determine in what circumstances where an issue has not been raised, whether or not it can be properly entertained at the appellate level. And in that particular judgment, Chancellor Bernard adopted the dicta of Lord Watson in Connecticut Fire Insurance Company versus Kavanaugh. Which states, and I quote, when a question of law is raised for the first time in a court of last resort upon the construction of a document or upon facts either admitted or proved beyond controversy, it is not only competent but expedient in the interest of justice to entertain the plea. The expediency of adopting that course may be doubted when the plea cannot be disposed of without deciding nice questions of fact in considering which the court of ultimate review is placed in a much less advantageous position than the courts below. But their lordships have no hesitation in holding that the course ought not to, in any case, to be followed unless the court is satisfied that the evidence upon which they are asked to decide establishes beyond doubt that the facts, if fully investigated, would have supported the plea. In other words, Your Honor, I would be suggesting to the court that this dicta would, if you choose to adopt it as a guiding principle, would say that the facts that are before you at this level, that the evidence upon which you are asked to decide establishes beyond doubt, is the words used, that the facts would have supported the plea. And that would be the guidance, the relevant guidance, I believe, that is supplied by this particular dicta.
I imagine that is probably particularly true in the case of fraud. I think I would imagine that it would be considered crucial that a person against whom fraud is alleged should know without any doubt at all that he was being accused of fraud.
And in conclusion, sir, I would want to say that having regard to that, it is our considered view that the submission of fraud in the instant circumstances should fail.
Yes. Thank you. That in Mr. Khan. I'd like to thank you, Mr. Khan, for your assistance. And you have been of assistance. And I would like to repeat what I said at the beginning of the hearing, that we do appreciate very much the sacrifice which you gentlemen have made in providing your services to this court. And it's very generous of you, and we commend you for it, and we appreciate it. Thank you.
Thank you very much, Your Honor.
Well, I think that I don't think it is necessary to have a reply to the Micahs. Mr. Nanda, I think that in any case, you had consumed your reply time when you were addressing. But is there anything in particular that you want to say further?
Yes, sir.
Well, in how many minutes?
Maximum 10 minutes.
Okay, I'm going to hold you to that. Come to the podium. And 10 minutes and no more.
Millets, much emphasis and reference have been made to the case of Dan Paul against the Bauxite Company. And appended to my submission is an article, rather as a chapter from the book, Commonwealth Caribbean Land Law by Sam Owusu. And at page 260 of that authority, the book itself.
At what page?
At page 260. The article is the last, the chapter is the last authority in my additional authorities. Page 260. Your Honor, it's the blue one. The blue, the one that was sent up only last week. Page 260. May I proceed, please, Your Honor? It ought to appear on your screen. It was held in Leneve and Leneve that a subsequent purchaser could not, by registration, obtain priority over an earlier on registrable document if he had notice of the unregistered registrable document. We can transpose that principle over to this case because the facts are almost on all fours. And then I invite your honors to look at the last paragraph, addressing this issue in the Guyanese case of Dan Paul and the Demerara Bauxite Company Limited. Locke J said, unless reserved by the conveyance itself, interest in immovable property which are required to be registered, if not registered, are void against a purchaser, even if he has actual notice of those interests. That is so in this colony as it is in England. And the author's comments are important. The last sentence of Lockwood J's statement, of course, is palpably erroneous with respect. And then he went on. And I think that the passage that follows that, I don't wish to read it because in the interest of time.
Who wrote this?
Sam Owusu, please. Doctor, I think he has a PhD. A lecturer at the University of the West Indies, Cave Hill campus. And on the following page, Your Honor, he concludes his discourse. And he analyzes very importantly what appears to be the conflict between the Deeds Registry Ordinance, two sections in the Deeds Registry Ordinance. And the discourse that follows there is very important or instructive in terms of the issues which have been raised here. And he concludes this way. The two provisions, the following page, page 262. The two provisions could have been reconciled and interpreted to mean that a registered transferee takes his interest subject to the enumerated claims and other subsisting interests. And that transferee takes free from any other interest if he is adjudged a bona fide transferee. Where he is affected with notice, he cannot be a bona fide transferee so as to be able to take free of the interests which are not registered. In other words, if Ali Mohammed is adjudged a bona fide transferee, he cannot take free of Ramdass's interest, Ramdass's agreement.
Unless he is together.
So first of all, the first step is to adjudge him, but decide whether or not he's a bona fide transferee. Because it is only if he is a bona fide transferee, then he takes free. And that is the analysis presented, which I think, Your Honors, are very important.
On the other hand, Mr. Nanglau, why do we need to import the word bona fide from Section 13, dealing with leases, into Section 22, so as to read the third line of Section 22, shall vest in the bona fide transferee, etc., etc. Why do we need to read in bona fide transferee when the protection given to someone who loses out is provided by the proviso to Section 22, so that if a transfer is obtained by fraud, then there's 12 months to do something about it. But doesn't that, by implication, oust any implication of bona fide into Section 22 before the word transferee?
The word bona fide is introduced in the equation by virtue of Section 14.2. Section 14.2 of the Deeds Registry Act, and that's where it enters this discourse here by virtue of Section 14.2.
13.2, you mean? But again, that deals with leases of any immovable property, and it deals with bona fide transferee. Why do we need to have bona fide put into Section 22 when you've got protection by being able to get everything set aside for fraud if you act within 12 months?
Well, clearly, if it is that you are not bona fide, then the fraud comes in. That's the only inference that one can draw. And that is why I have to disagree with my learned friend's very restrictive interpretation of the concept of fraud. Fraud is much wider Moral turpitude is not necessary. Artifice is not necessary. A desire to cheat is not necessary. Fraud is a very broad, any transaction that offends the conscience of the court, any transaction where one party takes advantage of the other or takes advantage of a peculiar position that he finds himself in, or any transaction that would be unconscionable for the court not to interfere with when there is unjust enrichment, etc., are all occasions where fraud can be imported. And that is the essence of, and I gave in that the thick authorities that I submitted earlier. I gave examples of fraud as discussed in the book, Equitable.
But Mr. Landau, there would be no need for the proviso in Section 22 if everything only vested in a bona fide transferee, and you're not a bona fide transferee if you know of an earlier contract. There would never be any need to fall back on the proviso for fraud. It's much easier to prove someone's not a bona fide transferee in the first place.
No, that is correct, except it is by fraud. The section gives you now the mechanism by which you set aside the transport. You are not a bona fide transferee, and therefore you are now afflicted by fraud. And it is the section, the proviso gives one the mechanism, is the key to open the door to set aside the transport. And of course, bona fides and notice and so on is only one aspect of fraud. Fraud being a very wide concept. And that's the point I wish to emphasize.
So you're saying that the proviso to Section 22, where it speaks of fraud, it encompasses persons who are not bona fide purchasers?
That's correct. That's absolutely correct.
So in Section 14, they use specifically the term bona fide purchaser. But in Section 22, they eschew that expression and they deal only with fraud. And you say we must interpret both sections in the same fashion.
That's what Mr. Owusu is making that point. That the approach adopted by Chancellor, by Laku J, was violative to very important and established canons of construction. And Millard, Mr. Pollard,
was Justice Laku dealing with leases? Section 14 is about leases.
No. What? Section 14 dealt with leases. No.
13, not 14.
Is it 13?
13.
Yeah.
The book, I'm reading from the authority, it has 14. 13.
It's actually 13.
Well,
yes.
In the office.
Yeah, and the author is saying that the statute should be construed as a whole, and that each part should be considered as effective and not redundant. And then there's a Latin phrase there which I will not attempt to pronounce lest I injure myself.
But Mr. Landa,
Yes,
you apprehend that there is a distinction between a transaction that can be set aside for fraud and one that can be set aside if the person is not a bona fide purchaser. Those two things are not identical.
My respectful position is that fraud is such a wide concept that it will invariably include a position where a lack of bona fides affect a transaction. Because you're going to benefit from your malifides. You're going to benefit from a wrong. And a court of equity will never allow a person to benefit from a wrong that he has connived.
But the expression bona fide is usually, I don't know if it's always tied to it, but it's usually used in conjunction with the expression bona fide purchaser for value without notice. And I thought that the purpose of the thrust of your assertion was that the protection given by the Act did not apply to someone who was not a bona fide purchase of a value without notice. And that is a specific category of case which may or may not be categorized as fraud. But obviously there are a lot of other circumstances outside of those in which transport may be obtained by fraud.
That's correct.
I mean, I imagine it might be a fraud on the vendor.
You know, a safe mechanism that I will employ is the quotation which I have at page 11 of my additional submissions, and that statement is taken from Alicock and the Demerara Bauxite Company. There's a definition of fraud there. It's on the screen. It is now clear, however, that the word fraud, and of course they're speaking of the Limitation Act, but I see no difficulty in importing it into the Deeds Registry Act, is by no means limited to common law fraud or deceit. Equally, it is clear that having regard to the decision X, Y, and Z, that no degree of moral turpitude is necessary to establish fraud within the section. What is covered by equitable fraud is a matter which Lord Hardwick did not attempt to define 200 years ago, and I really don't blame him, and I certainly shall not attempt to do so now. But it is, I think, clear that the phrase covers conduct which, having regard to some special relationship between the two parties concerned, it's an unreasonable thing for one to do to the other. And even if you can take it out of the relationship where they owe a duty to one another, any type of relationship that will offend against the conscience of the court. And if Your Honours will look at the authority that I cited.
Yes, but we don't going to take any more time, I'm afraid.
Yes. And to conclude, Your Honours, I rely on the case of Chandra Narayan Dubey and the Attorney General for the proposition that as a court of final resort, a court of last resort, this court not only has the jurisdiction but certainly has a duty to end all matters of controversy that arises in a case. And that is what Her Honour Chancellor Bernard, as she then was, attempted to do in that case, because it was clear and patent from the record that issues of estoppel was there. Of course, it was not pleaded before, and Her Honour using judicial innovation.
But they hadn't withdrawn the issue of estoppel.
That is well, it was never live before.
Well, exactly.
But in this case, I asked that in fact, that is a plus, because it was an issue, so that it was not something, fraud is not something completely new here.
Mr. Nandlal, you yourself, I think, summed up the difficulty you faced.
Yes, I did.
You did it very compactly and very much to the point. And I'm afraid that difficulty remains something that we'll have to consider together with your submissions, of course, as to why that ought not to deter us from considering fraud and making a finding in your favor on that subject.
And one final sentence. The position on the ground is presently is that Mr. Ramdass is in occupation of the land and has been in occupation of that portion of land.
Orders on his behalf.
Sorry?
Orders on his behalf.
Ramdass'
Because
behalf.
he's dead.
No. Ramdass is alive. My client is Ramdass.
Oh,
Yes.
All the others have died except Ramdass. Ramdass is in occupation of his portion of land which he has. Ali Mohammed has a transport for a larger section which includes, and his people are on his section of that land. And he only paid half the purchase price. You see, these are important factual...
That's more than one sentence, Mr. Nandlal.
No, he has transport for an entire section which he has not paid for.
Mr. Nandlal, thank you very much.
You're most welcome, Your Honor. And it was a pleasure appearing before this court again. Thank you very much.
We reserve our judgment in this matter.
Very good.
All right.